Thank you, Program Director, the Deputy Minister of Social Development, Ms. Henrietta Bukhupane Zulu, the Acting Director General of Social Development, Mr. Magwaza, Acting CEO of SASSA, Ms. Rapahle Ramahupa, Acting DDG, Comprehensive Social Security, Mr. Van Friede, ladies and gentlemen of the media, thank you very much for being part of this media briefing. This briefing is about informing South Africans about the amendments to one of the most important pieces of legislation in the Social Assistance Act. Cabinet received proposals from the Department of Social Development for amendments to the Social Assistance Act and approved its release for public comment. These amendments include, amongst others, changes to the administration of social grants, which will improve the efficiency of the appeals process and the operationalization of the Inspectorate for Social Assistance. The amendments also seek to establish a supplementary benefits fund, which will enable government to provide funeral benefits to the elderly and a savings vehicle for caregivers of children with the aim of linking social grants to developmental activities. The amendments also allow the Minister of Social Development and the Minister of Finance to make additional payments for certain grants. This will enable the introduction of the policy approved by Cabinet in December 2015 for the payment of additional amounts for the child support grant to orphans and children in child-headed households. On the administration front, as mentioned, the amendment bill provides for efficiency, improvements in the management of appeals, and for the setting up of the Inspectorate as an independent unit within the Department of Social Development. However, I am aware that everyone is interested in how our social development entity, SASSA, will be paying social grants from April next year at the end of the current contract with CPS. Program Director, it is on record that SASSA has been paying grants for more than a decade now, and before then, various departments of social welfare in provinces were paying out grants, and then the department had to also take over, and then at the end there was SASSA. And therefore this says that it's not the first time we terminate or we have to come to the end of a contract. For the first time, so much hype has been created in the public space about the system, and this poses unnecessary challenges as it affects the market and the confidence of potential suppliers. Over the last 5 years, SASSA has been planning to implement a new payment system which it will have more control over. In the contrary, SASSA has experienced a number of setbacks through court challenges and various other forms of interference. In 2014, SASSA made attempts of issuing a new payment contract, but a potential bidder tried to influence the tender specifications through the courts. What is happening now is an unprecedented amount of requests and media opinions trying to either gain information about payment specifications before SASSA releases it to the market. This includes leaked information that jeopardizes procurement and continuous questions to undermine government's ability to deliver the service which destroys supplier confidence. This unfortunately creates many challenges. I'm confident that the new CEO of SASSA will be up to the task and work on the foundation that was created by Dr. Virginia Peterson, who did her work with excellence. We are also confident that the transitional process will run smoothly, as that has happened before. The current appeals process in the Social Assistance Act provides for the administrative review of the decision within SASSA. This is causing unnecessary delays in accessing the right to appeal in relation to social grants and delay access to administrative justice. In the current process, if a person is not happy with the outcome of their grant application, they need to first approach SASSA within 90 days to request them to reconsider their decision. SASSA also has 90 days to respond. If the appellant is still not happy, they can appeal to the Independent Tribunal for Social Assistance Appeals within 90 days. And the tribunal then has another 90 days to adjudicate the appeal. And this is almost a year. The reason for this initial internal mechanism for reconsidering applications within SASSA was to limit the envisaged errors which could have been made by SASSA staff. SASSA has, however, improved their administration system significantly and has many built-in quality control checks and balances. Hence, there is no longer a need for the potential 6-month delay or before a person can lodge an appeal. The amendment bill proposes that a person will, immediately after receiving a decision from SASSA relating to their grant application, be able to directly lodge an appeal with the Independent Tribunal within a period of 90 days from the date of SASSA's decision. There are examples of appeals taking place up to 18 months to be finalized, mainly as a result of poor exchange of documents between SASSA and the tribunal. The amendment bill now sets clear standards that these documents need to be submitted to SASSA within 30 days of the tribunal request. As a result, the tribunal has 60 days to adjudicate the appeal, and this will allow us to hold each entity accountable without pointing fingers. The inspectorate is going to look into fraud and corruption cases, and the number of fraud and corruption cases over the last 3 years at SASSA indicates an entrenched endeavor by people inside and outside the entity to defraud the grant system. The grant administration system is currently plagued by illegal deductions, involvement of SASSA officials in fraudulent activities, unethical conduct of health practitioners, magistrates, police, home affairs, and so on. The case in point is a Ishowe case where there is a group that has been involved in this. They deliberately recommend disability grant applicants to people that are not disabled, and therefore officials accept cash to approve grants. The significant number of grant beneficiaries complain about poor service delivery at local SASSA offices, claiming that the elderly are often neglected. The anti-fraud function has been performed by the Special Investigating Unit in the past, and more recently by SASSA. The establishment of the Inspectorate as an independent entity, I want to repeat, within the department, but out of SASSA, will provide an improved level of oversight as well as governance over the social assistance function, because SASSA cannot be a player and a referee. The Inspectorate will have a specific mandate in terms of the Social Assistance Act to conduct investigations. It will further ensure that there is maintenance of the integrity of social assistance frameworks and systems, execution of internal financial audits, and audits on compliance by SASSA. This will be done through regulatory policy measures and instruments, investigation of fraud, corruption, and other forms of financial and service mismanagement, including criminal activity within SASSA and in connection with its functions, duties, and operations. On the policy front, the amendment bill introduces a new supplementary benefits fund and the ability for grant values to be increased for certain categories of beneficiaries. The supplementary benefits fund will focus on the issues of older people's burial schemes and savings for the children. And lack of death and funeral as social security benefits has left social grant beneficiaries vulnerable to exploitative and predatory practices by private insurance providers. Private insurance companies often behave as if they are unable to properly calculate the risks in low-income markets and do not have the scale to pull these risks adequately. Insurance for low-income earners is based on a high-risk profile with corresponding high premiums. Funeral costs are amongst the highest expense for low-income earners. Most poor South Africans are unprepared for the eventuality of death. Households without adequate coverage occasionally resort to loans and sell productive assets to cover these expenses. Family members may also be unaware of an existing cover and do not claim benefits. Older persons are not always aware of the underwriter and do not know who to approach when they experience problems. There is also bad conduct of financial service providers or their brokers. Beneficiaries are sold multiple products under the understanding that it's SASSA benefit. We have evidence that some brokers have even put SASSA logos on their cars when selling their products. The South African Reserve Bank also requested us to reconsider the preferential deduction facility that we provide through Regulation 26A. The introduction of the Supplementary Benefits Fund provides a vehicle for government to provide benefits such as funeral benefits and any other benefit linked to the beneficiary-based needs. And I also want to highlight that there is no new money that is going to come out of the funeral benefits as well as savings for the children. We will be using the same money that the grant recipients have, because some have been already part of the schemes. The actual benefits level will be determined between the Minister of Social Development and the Minister of Finance, at the time of implementation and annually, as it is with the grants. This will enable the provision of saving products. It will also allow government to expand its current investment in children through the CSG, early childhood development, schooling, and other services. Currently, the CSG ends at the age of 18, and we think that rather than going back and asking for new money, we must inculcate a culture of savings with young people, and that secondly, the grant ends at 18, and this is the prime age of an adolescent, and this is where young people need special things like sanitary pads, but also others go to tertiary institutions and they have special needs. But what we also need to attach to this is that only those that will complete grade 12 will access this. We don't want our children to say we do have our money that is put right there, and therefore immediately when we become 18, we are going to take it and do whatever we want to do with the money. It is going to be focusing on the development of the child and also ensuring that the child has a good start in life, like any other child that comes from a well-to-do family. Small savings fund can greatly assist during this time, and it will to some extent reduce the vulnerability of the youth, in particular young women who sometimes end up having relationships with older men and getting pregnant and losing their time in school. And additional grant payments. These are focusing on offense, more particularly a double offense, and secondly on child-headed households. And this was approved by Cabinet in December 2015, and therefore we are busy with the bill and we will take the process forward. There is still a lot of work to be done on this one, but it's also work in progress, because we're saying we don't want our children to fall within cracks. Those who want to stay on their own must be enabled to stay on their own and be able to go home, and we have to ensure that their lives go on, and we have to ensure that they have support services even if there is that funding. Thank you, Chairperson.